Ready? Okay, good afternoon. As previously introduced, this is Caleb Brimhall. He's an attorney in the Enforcement Department. He will explain the factors that enforcement uses in order to determine the appropriate disposition method or whether a penalty is appropriate. If it is deemed a penalty is appropriate, he will also explain the factors that could increase or decrease the penalty amount.
Thank you, Jimmy, and thanks for your and Dulce's input on the stuff we're going to talk about. Sorry you have to put up with me again, but we should start out with a joke because you guys all look like you're going to sleep, which is what I would be doing if I wasn't up here. So you guys want a joke? Okay. Who likes lawyer jokes? I like lawyer jokes. I like so I'm going to repeat one from yesterday. I'm going to tell you two, but the first one is, how many lawyer jokes are there? There's only 3. All the rest of them are true. And then what do you call 3 attorneys up to their necks in concrete? Not enough concrete. So I'm excited to talk to you today. I apologize again for my voice, but excited to talk about this. And please, if you have questions along the way, go ahead and raise your hand. We'll talk about it. We'll talk a little bit further about this in future slides, but risk is the biggest consideration in how non-compliances are disposed of. Therefore, as you reduce the risk to the reliability and security of the bulk electric system through your programs, through your efforts, through your controls, you set yourself up for more favorable and smoother resolutions of non-compliances. WECC seeks to partner with you all to accomplish its mission to effectively and efficiently mitigate risks to the reliability and security of the Western interconnections. Sorry, I'm supposed to be on that slide right now. So that's what I'm talking about. Bulk electric system. The same is true with the enforcement process. This does not mean that WECC and you all will always agree, but it does mean that we can add and should agree that we can and should agree to disagree in protective and professional ways and keep the focus on the reliability and security of the bulk power system. And as Jimmy said, we're going to talk about just how we do that. How do we determine what a disposition method is, and how do we assess penalties if we get there? And as we've discussed earlier, we want to partner with you, we want to work with you, and we may disagree, but we can agree to disagree kindly and professionally. Here are, these are the typical or default disposition methods with their corresponding risk. So unless the factors we discuss over the remainder of the presentation merit something else, that this is kind of a good guideline as far as where things are going to go. Because the other thing that I would note, just because no compliance exceptions are in British Columbia, both minimum and moderate risk must be filed as find, fix, and track. And then everything else is handled as a notice of alleged violation. Also, WECC within the U.S., we actually determine the disposition method and the penalty, but in British Columbia, we give recommendations to the British Columbia Utility Commission. So as mentioned, we're going to talk about risk, and barring very extenuating circumstances or rarely seen egregious behavior, risk is the driver. That's what we look at primarily as we're thinking about what disposition method should we look at or what the penalties should be. So the potential impact, so risk is the potential impact times the likelihood of occurring. So potential impact is kind of the worst case scenario, given the inherent risk of the registered entity and the specific BES assets and the non-compliance involved. The likelihood allows consideration for the amazing things that you all are doing to compensate for the risk that the non-compliance presents. As stated in bullets 3 and 4 here, we look at mitigating factors and internal controls to see what compensating measures help reduce the likelihood of the risk occurring. So some of the factors considered as we're considering what disposition method we should use, and the number of instances, and as we talked, I mentioned this a little bit earlier, but the number of instances, so outside the normal based on facts and standard requirements at issue, number of instances isn't necessarily a negative. Often we find that entities with robust compliance programs actually have quite a few reports. In fact, that's why, and I'll put a plug in for the self-logging program. Self-logging program is something that we're very interested in because it allows us to say, you as entities have great things going on, and because of that, you're taking care of a lot of the things that need to be taken care of. And so, in particular, the self-logging program, there may be multiple self-logs, but those may all be good instances showing that there's a robust program going on. Duration, which is both the time it took to discover the noncompliance and then overall duration of the noncompliance, is a strong indicator as well of the controls that we've been discussing. Compliance history tells us whether or not the same issues are coming up over and over again. The number and types of root causes, again, is an indicator of whether or not it's repeating or whether these are new issues and your program's continuing to improve, or if the same issues come up again. Mitigation complexity, we look at to see, the failure to completely mitigate. Was it fully mitigated? Was it not fully mitigated? And that plays into it as well. The level of cooperation, and one of the things that I can say about cooperation is I love the level of cooperation. As I've been here at WECC since August, I haven't engaged with any entity that has not had just stellar cooperation. We appreciate all that you're doing and want to work hand in hand with you. So those are some of the things that we look at. We look at those to determine whether or not what disposition method, should it be a compliance exception? Should it be a find, fix, and track? And then there are certain things that we don't have discretion on, and we must go with a full notice of penalty. So these, we don't have discretion. If it's a serious risk, extended outages, loss of load, cascading blackouts, vegetation contacts, systemic or significant performance failures, intentional or willful acts or omissions, those are the type of things that we don't have any discretion on. And so those must go as a full notice of penalty. So we're going to talk a little bit about compliance history assessments. We'll deep dive into that for just a minute. So when we look at compliance history, there's two steps. Step one is it relevant? Step two, is it aggravating or not aggravating? So there are three things we look at to determine whether or not it's relevant and whether or not and then we go on to distinguish whether it's aggravating or not. So we look to see if it's the same or a similar standard. So for example, SIP 7R3 and SIP 7.6 both involve security patch management. So that's what we mean when we talk about a similar, that there's been a change in the standard, and they both deal with patch management, but they're under a different standard and requirement. So FAC 9.1, R1, and FAC 8.3, R6, for example, both involve ensuring facility ratings are consistent with the facility rating methodology. So that's an example of same or similar standard. Regarding affiliates, there's some things that go into this. If we deep dive into that analysis, then we'll talk further about it. But essentially, we're looking to make sure that if there's a common compliance program and there are multiple different entities registered under different NERC IDs, that common compliance program, we're making sure that whatever happens is taken care of across the board. So if there are other affiliates that may have the same problem, that's being looked at. The 5-year look back, 5 years, the way we look at it is 5 years from the start date of the current noncompliance. And was there any noncompliance that was ongoing within that 5-year period? And that's what we consider. Now, that provides a stopping point. That's not written in stone anywhere. If there's other issues or something that we think makes sense to look that's past the 5-year window, we'll look at it. But that's kind of the rule of thumb. We look at 5 years unless there's some reason to go outside those bounds. And then we can, but don't frequently go outside those bounds. So once it's determined that there is relevant compliance history, then WECC looks closer at the facts, causal factors, and mitigating activities of the prior relevant instances of noncompliance to determine if the prior noncompliance should be differentiated from the current noncompliance or aggravate the current noncompliance disposition method or penalty amount. So in regards to aggravating, so we look to see, are there repetitive violations? And as we talk about both the aggravating and the mitigating, we've been talking a lot about risk, and that's what it's really all about. That's the why. So why do we have aggravating? Why do we have mitigating? Because these aggravating factors tend to show that there's an increased risk to the reliability and security of the bulk electric system. So repetitive conduct also points to failures in compliance programs and activities and those things that are going on, or failures to fully flesh out the causal factors from previous non-compliances and what's gone on there. And of course, programmatic failures present elevated risks to the reliability and security of the grid for obvious reasons. And so that's something we look at as well. And I can also say happily that I haven't come across any programmatic failures. So I've been here working, and it's exciting to see all the good things that everybody's doing. So those would be reasons to aggravate. Reasons not to aggravate, if there are different root causes, if there's prior mitigation would not have prevented the current non-compliance. We look at the different standard parts there. And then other reasons. Is it a high frequency activity? Has the entity just overhauled a program or a process? And so they're in the process of making significant improvements. One of the things that, and we talked a little bit about this yesterday, but I'll touch on it briefly. As we look into the causal factors and we're looking to process and enforcement action, that's one of the reasons that we really deep dive into the causal factors and make sure we found them all and that they're specific. So if if we're saying it's a issue, I may do this. I'm going to talk like this. So we look at the causal factors to see if was it a deficient process? If it was a deficient process, then then we ask further questions to make sure we can fully understand what it was in the process that had the issue. The reason why that's important is down the road, if there's another instance of noncompliance, and for example, in the self-logging program, you're continually improving your program, you're doing great things, but if there's another instance of noncompliance, we want to be able to look back and see, was it the same issue or was it a different issue? And often we find that entities with really robust programs participating in the self-logging program are continually finding things and improving their programs, and we can look at, when we have that specific information, it allows us to differentiate what's happened in the past from what's going on right now. And that helps us determine whether or not we have to aggravate it or if we can differentiate it. So in regard to, if we go through the process and it's not a compliance exception or a find, fix, and track based on those factors, then we if it goes into a settlement or a full notice of penalty, or in BC, a notice of alleged violation, then we start looking at penalties. And we're going to talk a little bit about what do we use to look into penalties. So we'll address some of the other factors in depth, but some of these we've already talked about. So the base penalty amount, the general factors, we've talked about some of those. Assessed risk, although not explicitly called out during the earlier discussion, also incorporates the violation risk factor, violation severity levels, entity size, violation duration, and directly relates to the risk. And the violation time horizon also is incorporated into that assessed risk. So these are the aggravating factors. So things that we look at to potentially aggravate a penalty. So compliance history, repetitive conduct, we've talked a lot about that. Failure to comply with a remedial action directive, intentional violation, concealment, resistance, impediment, non-responsive, and lack of cooperation and management involvement. So we'll talk a little bit about each one of those in turn. Remedial action directive, although we don't see many of these. A remedial action directive, as a reminder, is an action other than a penalty or sanction required by a compliance enforcement authority that is to bring a registered entity into compliance with a reliability standard or to avoid a reliability standard violation, and is immediately necessary to protect the reliability of the bulk power system from an imminent or actual threat. So if an entity violates the reliability standard requirements, despite receiving related remedial action directives, NERC and regional entities shall consider increasing the monetary penalty. So if there's one that exists, but there's still some violations that occur for failure to adhere to that, then the penalty then increases. Intentional violation, this one's somewhat obvious, but yeah, obvious, as we tie that back to the risk, intentional violations obviously increase the risk significantly to the bulk power system. If we have people intentionally doing things, unfortunately this rarely occurs, but if we have intentional misconduct, staff refusing to implement operating instructions or willfully refusing to adhere to NERC requirements. Concealment, resistance, impediment, non-responsiveness, and lack of cooperation. Again, for obvious reasons, this increases the risk, and we want to avoid increasing the risk to the reliability of the bulk power system. So some examples would be maybe intentionally withholding, altering, or destroying evidence, refusing to provide comprehensive responses to requests for information, and then unwillingness to work reasonably throughout the enforcement process. And anything that's hidden or then those are risks that we don't know that are actually going on. So another thing we look at is management involvement. And again, these are aggravating factors. So why, is the entity's management or individual, are they directing, condoning, or willfully ignorant of violations? Are they tolerant of violation? And the presumption is that if management's negatively involved, that the penalty will be doubled. Then we get to the happy stuff, the mitigating factors, and I'm happy to report, and I'm sorry you guys have to deal with my voice. It's like cracking. I feel like I'm going through puberty again. So apologize, you guys are all having to put up with this. My throat just went crazy on me. And so thanks for your patience. But mitigating factors, and these are the exciting ones. Like it's kind of like doomsday, the last 5 slides. Fortunately, we don't deal with that much. And we really thank all of you for that. There are some amazing entities doing amazing things in the Western United States, and we love all of you for that, and it makes our job much better. So the mitigating factors, the first one is, and just as aggravating ones, of course, increase the risk. Mitigating factors, the reason that you get benefits is because it's reducing the risk, and that's what we're focused on. The reliability and security of the grid is what we need to all work together to make sure is paramount in all that we're doing. And so that's why mitigating factors give an opportunity for us to give credit and reduce that penalty amount. I clicked the wrong button. There we go. Presence and quality of internal compliance programs. And we talked a little bit about this in the earlier panel and the importance of internal controls. But I want to spend a little bit of time on this because having come from some small entities, I think it's really important. It's not the complexity of the program that makes it effective. And so it's really important that, and we had an individual from a small entity stand up and ask about, what about small entities? And it's just really important to know that whatever your size is, if the controls are right sized for your entity and you're striving to implement them correctly, that those are huge and they're important. And we don't have to, when we talk about the presence and quality of an internal compliance program, it's not that we want to roll up on site and there's going to be a gen suite stood up and you've got massive amounts of internal controls that may or may not help you, but you can have a very effective internal compliance program that uses the tools you have in place. And that's just as, so it's the impact we're looking for. Is it really reducing risk? Is it really increasing the reliability and security of the grid? And you can do that in many different ways. And so we think that's just really important. Want to emphasize that for small entities or big entities, we're going to look at it, and it does not have to, the gold plated is not necessarily what makes it effective. And so we want to see how effective that is and how effectively you're implementing it. And the example that always comes to mind, when I first started in compliance a long time ago, we had a computer maintenance and management system at the power plant that I worked at, and we made sure, so we didn't go out and get another program, but we just made sure that everything that was compliance related was in that computer maintenance management system. The technicians knew what needed to happen. I, as the engineer, knew that what needed to happen. And so we made sure that that was all in there. It was reviewed, and that we had a plan for within that system for, it was a printout that told us exactly what we had to do and when we had to do it and how we got it done. And it was the system that was already in place. We didn't have to buy a new one. It's okay if you buy new ones too. The other thing that helps us bring that penalty amount down is cooperation. So and this of course is under very rare circumstances that we're not getting cooperation, that everyone's being cooperative, and we really appreciate it. And then one of the things that we look at is how quickly the entity self-reports. There's kind of a rule of thumb, and I appreciate yesterday somebody mentioned this, that that 90 days is really something that we want to request, that you guys get it in within those 90 days. Do your best to do it, just so it doesn't drag on. That's not an actual requirement that you're going to get, dinged on, but it's something that allows to make sure that those aren't sitting there. But it's something we look at. If there's a non-compliance that was found a long time ago and it doesn't come up for a very long period of time, that's why we've asked that all the entities, when you find something and you determine it's a non-compliance, that you go ahead and get that reported in a timely manner. And then, of course, the cooperation and request for information. And we talked a little bit about it earlier, but love the fact that we're now assigned to specific entities and get to work with them. It's really fun to be able to receive phone calls. I had a phone call last week, actually, from an entity that reached out and said, "We have a question. What should we do about this?" And we got on the phone and we were able to talk through it. And that cooperation helps all of us because we were able to find the right answers. And that particular question was, how do we've found potentially an increase in scope. How do you want us to handle it? How do we get it to you? And we had that conversation. And that entity reached out before just filing another self-report, and we were able to determine that should be just a finding update under a current non-compliance. So it's stuff like that helps in the penalty calculations, but also helps in all the work that we're doing. Then self-reporting, and of course this one's obvious. We can't be everywhere, and with our goal of reducing the risk, taking care of our customers, making sure that the lights are on, that self-reporting is important, and that it's done promptly and comprehensively. So those are the things that we get to use to reduce the penalty, and then the penalty assessment factors. So these are final adjustment factors and things that we get to look at. Settlement credit and extenuating circumstances. And settlement and accepting responsibility. And really focusing on the why. As we work together and we're able to settle more serious instances of noncompliance, that obviously allows us to focus more on mitigation and the reliability and security of the grid, and less about fighting over the nitty-gritty of what occurred. And so that's one of the reasons that's an opportunity for us to be able to give credit for being able to do that, and also taking accountability and ownership. And that one's pretty obvious, because when you were a small child and you didn't accept responsibility, but you took the punishment and you were just mad about it, and that's obviously not good for any of us. And so if there's something that's really gone on, then taking accountability and being willing to go forth and fix it is important. Extenuating circumstances. So this is another thing we can consider. So when unique extenuating circumstances cause or contribute to the violation, such as a significant natural disaster or pandemic, then we can look at reducing or potentially even eliminating the monetary penalty. And we've had some of those in recent history. We had a pandemic that hit. We've had wildfires that have caused potential issues. And the important thing is that it's not foreseeable, right? An extenuating circumstance isn't something that's foreseeable and preventable, and that there was just no action taken, but rather it's something that was really out of the control of the entity. And then finally, case history research. So as we get to looking at both dispositions and then the penalty amount, there's an enforcement attorney that goes back and looks at prior dispositions, both the method and the penalty amount, to make sure we're striving to be consistent and resolve instances of noncompliance in a consistent way. And then the goal is to be consistent and provide fairness in enforcing instances of noncompliance. And with that, do you have any questions about our discussion here about disposition methods, about penalty calculations? Hi, Monica.
Hi, Caleb. Just a quick question. For those self-reports or open enforcement actions that are somewhat old, and there's been mitigations measures that have already been implemented some time ago, does WECC kind of consider that as part of the enforcement processing in regards to the risk of those areas, because they've already been addressed a number of years ago? Would there ever be possibility in having like a, what's the word I'm looking for? Statute of limitation on a certain issues that had already been addressed a number of years ago? Management has changed, processes have changed, etc.
And we appreciate that question. And we take all those facts and circumstances into consideration. Unfortunately, there's not a statute of limitations, although that would be amazing.
Yes.
And but there are no statute of limitations, but we do take that into consideration. So we apologize, and we're working on that backlog. But there are definitely some that are many years in the past, and we appreciate all that you all as entities are doing to mitigate it. Unfortunately, yeah, we have to treat them pretty much all the same and really evaluate them based on the facts and circumstances and go through the same criteria that we evaluate all of them, even though some of them are older.
Okay, thanks. Well, I just had to ask.
Yeah,
But
no,
thank you.
we appreciate the question.
We have a question online. Do you factor in newly registered entities and how new their program is when addressing a self-report violation?
So we look at all facts and circumstances, but just like if we had a new standard and there's an implementation date, there's no get out of jail free card. So I don't know if that answers the question, but it's similar to an implementation date. We have lots of entities in here that when we have a new standard that comes into place, there's an implementation date and they have to be compliant at that date. It would be the same for a new entity, that they need to be compliant at the date that the standard requires. And so we can't give a get out of jail free card, or because you're new, you didn't quite know what you were doing. We have to treat them all the same. Any other questions?
Great presentation, Caleb. This is an easy question, but for the entities that qualify for self-logging, in this presentation, we talked mostly about self-reporting, but for those that qualify for self-logging, does that factor in kind of the same way?
As far as the stuff we discussed in this presentation, factoring into self-logging?
Exactly.
It does, but because they're self-logs and because the entities that are vetted through the self-logging process have mature programs in place, we would never really expect to see, a self-logged, something that was self-logged and would elevate up, for example, to something that would be penalties, that we'd have to go to full notice of penalty, because hopefully we're working together and you all are aware of what's minimal risk and what's high risk. So so self-logs are always minimal risk. And so if it's not a minimal risk, then don't file it as such. Does that answer the question?
It does.
Okay.
Thanks.
And the one thing we'll mention there, and I think Josh is going to talk more about this, Joshua Yang from WECC is going to talk more about this, so I don't want to steal his thunder, but if there's ever a question, if you're a self-logging entity and you're looking at it and you're on the fence and you're going back and forth, like, is this a minimal risk? Is it a little higher risk? Then just as we talked about earlier, pick up the phone and give us a call. We really want to talk through that, and we can have a brief conversation to make sure we're on the same page before you file it. We're always happy to have that conversation if it's helpful.
Thank you.
There are no other questions. Any other questions? Thank you. Thank you very much for enduring my puberty voice today. And I'm sorry that you had to put up with it, but thanks for your questions. And I love getting to hang out with you and see you. We appreciate all that you're doing and look forward to working with you.